Well, good morning, everyone. My name is Paul Santamaria, and I'd like to welcome each of you to this morning's seminar on the preparation of evidence for trial and interlocutory applications. The title of the seminar is Witness Statements, Affidavits and Expert Reports, 10 Golden Rules for Undermining Your Client's Evidence. I had to read the title twice, having wrongly assumed it was intended to refer to one's opponent's evidence. But of course, in identifying common errors in preparing one's own evidence, that will equip the lawyer with the tools for impugning the case put against you by your opponents. But first we need to have proved our own case or defence, as the case may be. Now I have to say this is an extraordinary roll-up, so I wonder, is there some issue about CPD points as we get towards the 30th of June? Or is it simply Michael Green, the success of the marketing department? I'm not so sure. But it's very good of you to get up so early in the morning and come to join the seminar. We will compete from time to time with the jackhammers behind me as the restoration of the apartment building proceeds at some pace and at great inconvenience and nuisance to the barristers on this side of Owen Dixon. I'd like to introduce our two presenters this morning, Travis Mitchell and Sam Muir, both members of Green's List. Their detailed profiles, I'm sure, will be included in the seminar papers, and so they can be read at your own leisure. But in the briefest of overviews, can I say that Travis practices primarily, but not exclusively, in the commercial and equity divisions of the Federal, Supreme and County Courts. Equity used to be called the whispering jurisdiction. Voices were never raised. One would compliment one's opponent on his or her submissions, and everyone carried a Mont Blanc pen. But of course, the internet has changed all that, so this confraternity of the equity bar has been replaced by egalitarianism, to the point where Travis has his own blog. It is called Equity, Trusts and More. And so every day, thousands of people have their say about recent developments in the rule against perpetuities. But I recommend you visit the blog. It's well worth doing. And Travis will be our second speaker this morning. Our first presenter is Sam Muir. Sam practices principally in administrative law, tax, and commercial disputes. After the 1980s, with the notorious bottom of the harbour scheme, some of you might remember, it was no longer fashionable to be called a tax lawyer, and so the term revenue lawyer was invented. Sam is a revenue lawyer. Revenue lawyers tend to charge very high fees, own their own private jets, and wait at the table of the rich and famous. So we're fortunate that Sam has found the time to fit us in this morning. But to introduce our subject matter, I wanted to refer briefly to a couple of recent judicial observations about witness statements, or certain witness statements. Last year in a long judgment, Justice Judd had some things to say about the preparation of witness statements in the matter before him. The case concerned an investment scheme. Two plaintiffs had invested in the same scheme, and that was not the only similarity between them. In the course of his reasons, His Honour said, while each case must be assessed on its own facts, the evidence advanced by the plaintiff and Mr. VH was such as to excite like scepticism. The evidence prepared for the plaintiff and Mr. VH in the form of witness statements had striking similarities, His Honour said. That may be in part a reflection of overworked witness statements. Where issues such as reliance are raised, witness statements are often an unsatisfactory form of evidence in chief. The witness statements, he said, shared close similarities in content, such as the identical ranking of the 3 reasons why each invested in the company scheme. Important parts of the witness statements were expressed in virtually identical terms, and he concluded his précis by saying this: overworked witness statements discredit the witness, embarrass legal practitioners involved in their preparation, and undermine the trial process. I place little reliance on these formulaic passages. Ouch. So, this morning's seminar aims to identify common mistakes in the preparation of witness statements and affidavits, with special attention being given to the particular challenges presented by the preparation of expert evidence. So I'll now hand over to Sam.
Thanks, Paul. As litigators, we like to control the things that go on in the process that we seek to manage, and witnesses, of course, make us nervous because they're a part of the process that we don't have complete control over. Dealing with witnesses is a skill that can be practiced and can be improved, and there are a lot of things going on at a witness interview. The interviewing practitioner really needs to have a grasp of relevant legal principles, needs to be right across the documents in the proceeding, needs to know what the witness has said on past occasions, if there have been past occasions, and of course needs to have the headspace and time to develop that rapport with a witness that is critical to getting the witness to assist. It's true, and it remains true, that most cases are won on evidence in chief and not cross-examination. So witness statements are, of course, absolutely critical, and that decision, or those reasons by Justice Judd that Paul just took us to, are a perfect example of how damaging a badly prepared witness statement can be for your client's case. Well, the first item on the list of things not to do is conferring in the wrong way. The conference is, of course, the root, the foundation of a good witness statement, and conferences are difficult. I wanted to divide the discussion of conferences into 2 parts. Firstly, the practical aspects of a conference, and second, the ethical aspects of conferring with witnesses. The practical part is easier to deal with, and what it amounts to is proper preparation. And that includes preparing the witness. The witness needs to know what to expect from the process of being a witness and from the process of conferring. They need to know it's going to take time. It's unendingly frustrating when a witness turns up to a conference expecting it to last an hour and it lasts an afternoon or a day. Very often we underestimate the amount of time we need to spend with witnesses to go through the material, and for a witness it can be more frustrating. We've all experienced a witness whose eyes begin to glaze over at a particular point in a conference, and perhaps it's worthwhile considering dividing conferences or splitting them up over days if we have a sufficiently large amount of material to cover. And of course, in appropriate cases, a bundle of material, documents that is, that the witness is to review before the conference will save time in the conference, not just because the witness is familiar with the material, but because the witness will have already commenced turning over the information in his or her head before attending the conference. So prepare and start early. In most commercial cases, you'll need more than one meeting with a witness. You'll need a good note of your first meeting, and the earlier that the note is taken, the better, because of course the witness's memory is freshest earlier. A good note of an initial meeting between solicitor and witness is gold in a brief to a barrister. But likely you're going to need to go back to the witness and ask them about other things. As inevitably happens in these processes, you begin to discover new areas of inquiry, and you need to go back to your other witnesses and ask them about it. And it's for that reason that it's important to attempt to progress, to the extent it's possible, your process with each witness at an even rate to deal with that reality. And of course, you need to be prepared yourself. That is, by mastering the documents to the extent you can, and by preparing a chronology if you need to, if the facts of the case dictate it. Witnesses shouldn't be conferenced together. Believe it or not, practitioners have made the mistake of conferring with more than one witness at a time. This is inappropriate, of course, because of the possibility and of collusion, and even the appearance of collusion. The witness can be told that they might be cross-examined about conversations with other witnesses. Now, you can also tell a witness that they might be asked by the other side to speak with the other side. Now, the ethical conduct rules for barristers say it's a breach to seek to discourage a witness from speaking to the other side. Of course, there's no property in a witness, and a witness is and the other side is entitled to approach a witness and ask them if they'll talk. But it doesn't breach the ethical rules to tell a witness that they're not under any obligation to talk to the other side. Turning then to the other ethical duties engaged in conferring with a witness, well, the principal one is not coaching the witness. Well, what's meant by not coaching the witness? At the core of it would seem to be telling the witness what answers could be given to questions that they might anticipate receiving, or suggesting the kind of evidence that a witness should give. But there are other forms of coaching that also need to be avoided. One is discussing with the witness what the legal consequence or effect of certain answers they are to give might be. And another is telling the witness what another witness says about something, or showing to the witness a draft witness statement of another witness. That's, of course, not only coaching, but also gives rise to the possibility of collusion. On the other hand, there's of course a tension in cases where witnesses are struggling to remember, or witnesses' evidence appears to you on its face to be inconsistent. How do you deal with that? Well, the way to proceed in a witness conference ordinarily is to proceed by using non-leading questions. There's two reasons why that's so. Of course, it's a practice that reflects the process of giving evidence in chief, and it should therefore be applied to the preparation of witnesses, which are really a proxy for evidence in chief. But second, it enables you to draft a witness statement in the witness's own language, because the witness isn't simply adopting propositions that you put to them. I'll deal with preparing a witness statement in the witness's own language next. But to the extent possible, non-leading questions should be used in preparing witness statements. Next, it's appropriate to refer a witness to documents if their memory of events fails. And very often in commercial cases we find ourselves flipping through documents with witnesses as a way of prompting discussion. It is helpful, however, to attempt to exhaust the witness's memory before going to the documents as a sort of preliminary part of a conference. Another acceptable technique is to, where a witness memory fails them, to take them to the chronology and step through the chronology, because there's an inherent logic in a chronology that will occasionally, very often in fact, assist a witness put together their memory of the relevant events. And Finally, it's not improper to direct witnesses to inconsistencies in the evidence that they have given, or inconsistencies with documents. But it's important to take care not to suggest what the resolution of that inconsistency might be. That's a matter for the witness. Moving then to the second area where witness statements can fail, this is the justice-judge area, and that is substituting the lawyer's language for that of the witness. This is one of the hardest parts of drafting witness statements, in my opinion. The proposition is that witness statements are at their most persuasive when they're written the way the witness tells it. And there's nothing like the resonance that you get between a witness statement and the witness's mode of speaking when they're in the witness box to reassure a judge that what's in the witness statement is what came out of the witness's mouth in conference. On the other hand, one of course wants to organise the information that comes from the witness's mouth in a logical way, to rearrange it so that it's chronological, because that makes it the clearest for the reader, and of course to adjust it for admissibility, that is, to exclude irrelevant or inadmissible material, comment, argument. And so there's a balancing act to be struck between using the witness's language and arranging the witness's language in a way that makes it informative and admissible, persuasive. The worst offending against this rule is where the witness statement is full of legalese. Now, a colleague tells a story about a witness who's asked in cross-examination what he meant when he described a workman's defect as egregious. Now, it was obvious on pursuing that line of questioning that the witness didn't know what egregious meant. That's, of course, embarrassing for the witness, but it also reflects very badly on the practitioner. Second, there's a habit among lawyers, and we're all guilty, I suspect, of excessively using defined terms in documents. They really need to be kept to a minimum in witness statements. I suspect if defined, I suggest that if defined terms that are to be used in a witness statement, the term needs to be the shorthand that the witness ordinarily uses. That is, if the witness is a bank employee, it's customary for those employees to talk about the bank. No problem. Similarly, with a construction case, people talk about site. Again, no problem. But when you get lengthy acronyms, sometimes it's preferable to ensure that the acronym is indeed the way the witness would in their ordinary speech refer to whatever it is that's defined. Well, where your witness is on a first-name basis with a person mentioned in their witness statement, it's appropriate for the witness statement to use that first name. And if you have a witness who does use formal language, and a colleague gives an example of a gentleman of Indian extraction who did in his ordinary speech use expressions like, I most definitely did X, or I most assuredly did Y, then of course those can remain in. And be careful about striving for consistency in witness statements. Judges understand that people's memory of events are imperfect and that they differ. If witnesses don't remember a particular event, it's usually okay to say so. Absolute consistency between witness statements, as the example from Justice Judd's judgment demonstrates, is much less plausible than the existence of some variation in the way a witness or witnesses recall events. And complete consistency, of course, reflects badly on the witness and also on the practitioner. Word for word consistency between witness statements is, of course, a red flag that the statement contains the practitioner's words and not the witness's words. And finally, care needs to be taken to ensure that the witness statement doesn't overstate a matter that the witness is saying, so that the witness is required to back away or retreat from their statement under cross-examination. And so where a witness expresses something in an absolute term, it's appropriate in conference to test that absolute. I recently received a number of witness statements in a case that were drafted in a way that did impress me and reflect those principles. Because of the knowledge that I have about the facts of the case, it happens that I don't find the content of the witness statements plausible, but I do think the witness statements are, in that case, are persuasive. And that's because the witness's voice comes through in the statements, that one can almost hear the conversation happening in conference, and where a witness in their statement responds to a weakness or an inconsistency or an improbable aspect of their evidence, it's easy to read between the lines and imagine the interviewer's question and the witness's response in conference, and see that response on the page. Now, in my submission, that is a persuasive way of preparing a witness statement, but it's also a sensible approach for a practitioner who needs to make it plain that what's on the page is no more than the witness's words in conference. Well, the third area where witness statements can go wrong is by the inclusion of inadmissible material, or by the recitation of facts in a way that isn't admissible. I don't really want to spend too much time on the rules of evidence that are applicable, because of course they could be the subject of a whole separate presentation. But it's enough to say that if a witness's evidence is inadmissible, it will be objected to, and it will not be accepted into evidence, just as oral evidence would not be. And that goes not just for witness statements, but of course for affidavits used in interlocutory matters, in corporations matters, in bankruptcy matters. The most significant category of inadmissible material seems to be irrelevant material. And while the excision of irrelevant material from an affidavit or witness statement may not be fatal to a case, in fact it almost certainly won't be fatal to a case, it is a way of making your witness statement more fuzzy, less persuasive, and for that reason it should stay out. Far too many witness statements tend to contain irrelevant matter. And the other evidence point to mention in this context, that is commercial cases, is the business documents rule. As we know, many commercial cases are run and won and lost on the documents and not on the witness's memory. Witnesses often don't realise that a big part of what they do is put the documents in. And so it's important to know how to deal with documents. First of all, not to restate content of documents, except where an element of explanation of a document is required. So if there are acronyms that don't make sense, or a context that needs to be explained, then of course that should go in. But otherwise, a précis of the document really isn't required, other than to meet the requirements of the business records rule to make the document admissible. And the two elements to that, or the two general elements to that, really are: first, to show that the document is a business record. Ordinarily, by introducing a document in a witness statement, you'll cover that hurdle. This is an email received by me on date X. Well, it's plain from the context that that's a business record. It's a document received in the context of a business. But second, it must be shown that the representation in the document is made by a person who might reasonably be supposed to have personal knowledge of the asserted fact. That is, the hearsay fact that would otherwise be inadmissible, but is admissible through the business records rule. And often that involves stating the identity of the author of the information, or the person who entered the information into a database or a system, or the method by which information was entered and retained in a database or other system. It's important to ensure that that's covered off, because the inadmissibility of material in documents is, of course, a serious problem for a case. The fourth element, or the fourth pitfall, is the slavish adherence to precedent. Very often in our precedents we have the formal parts of affidavits already built in, and it's important to ensure that when each document is prepared, the formal parts are read and reread to ensure that the purpose that they intend to serve is indeed served, and that they're necessary in the particular case. It's also important to ensure that the boilerplate isn't inconsistent with the rest of the document. So, for example, one of the common formulas is the information and belief formula that's used in affidavits in support of interlocutory material. Incidentally, care is needed when putting evidence on information and belief to ensure that the source of information is identified. But frequently, an affidavit made in a proceeding contains a generalized statement that the deponent makes the affidavit on the basis of their own knowledge and belief, except where the contrary is indicated. But Travis was telling me about a case where that went quite wrong. A statement was made at the commencement of the affidavit that the following information is provided on the basis of my knowledge and belief, but nowhere in the affidavit was it identified which parts of the affidavit were made from personal knowledge and which parts were made from information and belief. And Travis's application, I'm really stealing your war story here, Travis. His application in that case to have the content of the affidavit not accepted into evidence was successful. And that's a serious blow for the party seeking to rely on that affidavit. In that case, I think the answer was a fix-up by the party serving the affidavit and an adjournment off to another date. But of course, there are consequences to that. And finally, there's the question of how to treat adverse material in a witness statement. This is an area really where an exercise of judgment is needed, but the basic proposition is that it doesn't help your client's case to try to avoid dealing with known relevant adverse information, or to try to fudge it or to gloss over it. Where there's a weakness in your client's case, it can often be the best approach to deal with it up front. And that can serve to head off cross-examination about an issue, which can, of course, be damaging but also unsettling for a witness, or at least take some of the sting out of cross-examination. Alternatively, there's the opportunity to consider whether a witness needs to be called at all. Where a witness who's available to your client and is not called, and that witness was in a peculiar position to offer evidence that might rebut an inference that the other side seeks to have the court draw, then Jones and Dunkeld says that the inference can more readily be drawn in the absence of that witness being called. But remember, this is a rule about inferences. The High Court's recently told us in a case called Asic and Helikar that this principle doesn't apply to diminish the cogency of a positive case that a party leads by direct evidence. Where you have positive evidence of the existence of a fact, the cogency of that evidence isn't diminished merely because you fail to call a witness who might be able to corroborate that evidence. And so if that witness to have possession of adverse information or to be susceptible to cross-examination on the basis of some adverse information, well, you may be in a position simply not to call that witness. And finally, of course, if cross-examination on the adverse material is not anticipated, as it's not known to the other side, then in the ordinary course, there isn't an obligation to disclose it in an adversarial civil context. Well, those are the matters that I wanted to mention in relation to witness statements. I'm happy to take questions now or at the end.
What we might do, Sam, is to have our break, and I should have perhaps explained at the beginning of the session. We're going to break for 5 minutes or so that people can recharge their cups of coffee, and then we'll have our second presentation. There's such a breadth of experience in this room as I look around and read the list of attendees that perhaps in the last quarter of an hour, what we might do is invite questions from the floor, but I would also like to invite people to contribute their own experience to the discussion. I think, and I wanted to endorse what has been said by Sam in particular of the preparation of witnesses to give evidence. We do this day in, day out, and I think the process becomes a bit passé for us. But it's really important, I think, as Sam was suggesting, that we really need to stand back and put ourselves in the position of the witness. Someone who has probably never been anywhere near a court before. And you really need to think, now, what is that person expecting from the process? Most witnesses that I've had to deal with are pretty anxious about the experience. That might be because of their anxiety of my presenting the case for them, I don't know. But most people don't like going near courts. Sometimes you have cases where necessarily the witness is going to be in the box for not just hours, but possibly some days. The preparation of witnesses in those situations, particularly where the witness has no professional qualifications or experience, is really difficult. And whilst I like to avoid war stories, I just want to say a couple of things about the preparation of a witness for a long trial in which I was involved, where the chap who was the principal witness giving evidence about a set of events that took place over a period of years, unwell, didn't want to be involved, everyone else had left the company, he was it. Not someone who was particularly good with documents, and scratched his head when I mentioned that he would in fact be questioned by the other side about the evidence he would give. And of course it was a task to keep him interested and willing and able. What we did in that case was to say to this chap, look, come in at 8 o'clock in the morning, we'll spend an hour maximum, an hour and a half. Here are the documents from January to July 1996. Read those over the weekend, and I promise you we'll go no further than those documents. So we set in place a regime where the witness would come in on a Monday morning. He was able to do the homework over the weekend, put a dictaphone on the table, and just had a conversation with him about his recollection, prompted by the reading of the documents over the weekend. I found that to be a very good way of preparing the witness. But what was really important about the process, I thought, was that you developed a cooperative approach to the trial. You also set about, along the way, answering his questions and anxieties about what he was being asked to do, because he was being asked to do something very, very substantial in his life. It also enabled you, as the barrister who would be examining him, calling his evidence in chief, to have a very good feel about the way he would be likely to answer questions, and that was important. It was also very important to take him across to court, sometimes when he wasn't under pressure to get to work by 9:30 on the Monday morning. We would have a cup of tea and we'd wait for something to start at 10 o'clock, and we'd go over and watch the process for half an hour. And the whole process of the judge entering the courtroom, of the associate calling things out, of witnesses being sworn in. For this particular witness, that was really important, and I think most witnesses fall in that category. They really have no idea what they're being asked to do. And the other thing I thought was important, and is important, is to avoid using words like cross-examination, because as soon as you start referring to cross-examination, they start thinking of things like LA Law and Miami Vice and things like that, where the defence attorney tears the witness to shreds with dramatic flourish. So you've got to disabuse the witness of that, and I think avoiding words like cross-examination, because all I can hear is the cross part, not the examination part, is to be recommended. So I've probably encroached upon our coffee time, but we'll gather again at 8:15 for Travis's presentation. Great.